All right. Well, welcome. This is the public meeting for the Dimple Dell Subdivision of the Utah Lake Jordan River General Adjudication. I'm Blake Bingham. I'm the Assistant State Engineer who is in charge of the adjudication section for the Division of Water Rights. With us here tonight is Josh Zimmerman. He's going to be the team leader. So as you file claims and go through that process, it's his team that's going to kind of do the boots on the ground and call you, contact you, and work with you. I have several other teams. Another team leader over here is Ashley Olshaff. She's working on some other books, but she's here to answer any questions you have. And you may have met, I think Sam's out in the lobby, is that right? So we have a couple staff placed around. Kind of the layout, the rules of engagement for tonight. You know, feel free to ask questions throughout the public meeting. We'll try to answer them if they are specific to your situation. I'll try to give a brief answer just because we have kind of a smaller crowd, so I don't anticipate being too much of a burden. But if we're chasing the rabbit too far down the hole, I might just ask you to stand by, and I'll stay afterwards, and we can answer those questions. Or you can step out and meet with Josh or Sam or Ashley, and they can answer your question if you're ready to get out of here and your curiosity's been satisfied. Just also, by way of, just so you know, obviously you received a summons as well as the notice with this. I just want to make sure it's clear that this public meeting is not, you're not obligated to stay here. It's simply for information purposes. This is the agenda. We're going to talk about the adjudication overview, kind of go through the process. We'll talk about what a proposed determination is, some significant issues in timelines, and then again, questions will be throughout if you have them. For those of you who are viewing online from home or from an online computer, if you have a question throughout the presentation, go ahead and email it to that email address there in the blue at the bottom. And at the conclusion of the meeting, I'll bring that email up and read it for the benefit of the group and try to answer it for you. If you can't get it to me before the conclusion of the meeting, go ahead and still email it to me, and we'll get a response to you one way or another. So, with that introduction, let's go ahead and kick this off. Usually I like to start these off a little bit to address some, I guess the needs of the crowd, because not everyone is proficient in understanding what a water right is. So we'll start off with some water rights 101. What is a water right? Well, a water right is it's unlike other types of rights or property rights that you're probably more familiar with. Really what it is, it's the right to use something. It's a usufructory right is what the attorneys like to call it. But it's the right to divert or remove from a natural source water and then beneficially use it. In Utah, water rights typically have these 5 different characteristics. They have a defined nature of beneficial use, meaning that's exactly what it sounds like it is. It's what it's being used for, whether that's for irrigation purposes, for domestic purposes, stock watering. There's a lot of different beneficial uses. It has a priority date, and what that is generally associated with the date of appropriation. It tells the water right owner and others where this water right falls in the line of getting water. Utah is a state that falls under the doctrine of prior appropriation, meaning the first to appropriate their rights get their rights first. Those who appropriate them subsequent to that are next in line. So you can imagine it's kind of a line of water rights. And so the more senior your priority date, the closer you are to the beginning of the line. A defined quantity of water for the diversion, we typically measure that in either cubic feet per second or an acre foot per year, annual acre foot. Those measurements are exactly how they sound. So if you can imagine a property that is 1 acre and has a water filled to 1 foot in depth, that is an acre foot. Specified point of diversion, that's really just a fancy word for saying where the water is coming from. So for underground sources, that's typically a well. That would be the point of diversion. For surface sources, it might be a head gate or a diversion dam, or there might be a spring box. And that's what when we talk about points of diversion or point of diversion, that's what we're referring to. Is where's the water physically removed from the natural source and used or conveyed to the place of use. Speaking of which, a specified place of use. And that's exactly what it sounds like. That's just where the water is being used. Nothing too crazy there. So usually when we send out these notices and the summons. We get a lot of phone calls, and a lot of the questions are, I want to know, I don't know if I have a water right. Can you tell me if I do or not? And that's a valid question, given that there's not a whole lot of understanding of what a water right is. But so we often answer that saying, well, you might have a water right, you may not know of it, especially if you moved into a house where it had been owned previously and the previous owner had appropriated a water right and not told you about it, and you've moved in on it. And so what we tell people to look for is look for a well, look for water coming from a ditch. That may not mean that you own the water right, it may mean something else like an irrigation company, which I'll get to here in a little bit. A spring box, those types of things. So anything but the water meter connected to the public utility, right, to the local municipal water source. So what a water right is not, a water right's not a share in an irrigation company. Now that doesn't mean that it's not related to it. So if you think of an irrigation company's shares, the company itself owns the water right from which it diverts, and then they distribute and administer shares. And so if you're a shareholder, you own a portion of that water right in theory through the company, or the company delivers water to you based on that prorated share in their company. And so you probably have an interest in this process if you are a shareholder in an irrigation company. However, the company itself, its board of directors and its president will be responding to these notices and filing claims on behalf of their shareholders. So the water rights, for instance, Bell Canyon Irrigation Company, they're the owner on our records of the water right that I just looked at before this meeting began. And the water right's not a connection to a public water source. Like again, it's not from White City or anything of those of that nature. Again, they own water rights. They collect it, treat it, and then provide that service to people who have service connections. So when I do these meetings, it's hard to explain what the purpose of an adjudication is without just giving a little bit of a history lesson. And so bear with me for a few slides. It'll help provide more context as to why this is important and why it's important for you to participate if in fact you do have a water right. So I'm just going to kind of give a thumbnail sketch of how we got to where we are. I promise it won't take too long, so bear with me for a second. So we all know the story. In July 23rd of 1847, the advance party of the Mormon pioneers entered the valley. They began diverting the waters of City Creek right away just to soften up the ground so they could get a late season crop in. Later, they built a shopping mall on top of it. 1848, Brigham Young declares there shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people. And that's a fundamental principle in the water resources of the state of Utah, is that it's a resource owned by the people. The division or the state of Utah simply administers it to make sure that there's equitable distribution and that there's reliability and those types of things so that people know when and how they can expect to receive their water. Well, between 1847 and 1850, what we now know is Utah went from being part of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. But the government really kind of just remained church-centric. And when I talk about church, I'm talking about the LDS church, all right? They filled that power vacuum. As a result of that, diversions from water, from streams along the Wasatch Front and throughout the territory of Utah were done on a communal basis to satisfy the immediate needs of the settlers. The doctrine of priority evolved out of that, in that those first settlers who established certain areas would come in, they would dig the ditches, divert the mountain streams, put them to beneficial use, and they would get what's called the primary right. They did all the work. However, subsequent settlers would come in afterwards, and they would want to share in the water, and so they would get a secondary right. So once all the waters, the average stream flow was taken up, that consisted of the primary right, and then any extra flood water or high water would be considered a secondary right. And this is a system that kind of mixed later with the concept of priority with the mining claims, and that's kind of where we are today. We have this doctrine of priority where first in time is first in right. And feel free to take as many photos of these slides. These slides will be available online on our website, as well as the video recordings will also be available. So you can continue to take whatever pictures you want. Just don't want to have you worry about it in case, so you can look at this later. Conflicts, because the church was kind of the governing body, conflicts were settled through those channels, right? You had the bishop's courts for minor issues, and then if they didn't like what the bishop had to say, they'd take it to the stake high council, and they would kind of serve as an appellate court. And that's just how things rolled in those days, because they didn't really have a different system. As we move into the territorial context, the first Territorial Legislative Assembly passed an act that tried to remove that power from the church and put it in the hands of the county court to control all water rights. Salt Lake County was really the only county to assume these duties. The rest of the state kind of ignored it. And it was really moot anyways, because to be a county judge, you were elected into that position, so you can imagine who they are electing into those positions, right, as the bishops and the stake president. So it was pretty much the same thing as the church court in any case. In 1877, the United States Congress passed the Desert Land Act, and that was an effort to try to get people to move out west, to settle the west, and so they wanted to do that, and they wanted to give free land, and to have that land, though, you had to be able to cultivate it. You had to prove that you're cultivating it. Well, subsequent to that act, there was a couple things that were important. First of all, it severed the title of the water from the land, okay? Now, that had kind of already been happening in the West, but this made it official. Back east, if you owned a property adjacent to a river or a stream, you had a riparian right, meaning you had the right to use that river. Well, this act in essence severed that. So even if you owned property next to a stream, didn't mean you could divert and use it on that property. And it also meant that if you owned property located a long ways away from the stream, you could divert, move that water, and use it there. Another interesting aspect of the Desert Land Act is it delegated authority for the administering of water rights to the state or the respective territory. And again, that seems pretty common. You know, it seems like a common sense thing for to do, but if you think about it, it maybe not has been, it is a little bit more revolutionary than maybe we give them credit for, because at the time, the Government Land Office was still issuing patents for land, so they were controlling the land. You would think they would do the same thing for water. Well, this kind of turned that on its head, and the state became the governing authority for administering water rights, and the federal government became the administrating authority for administering property rights, or continued to be that administering authority. In 1880, again, the county courts kind of failed in administering water rights, so they tried to appoint these county selectmen who would go around and record what water was being used and issue certificates. It was pretty much ignored and is even, I think, ruled against the unconstitutional. It kind of gave too much power to an executive branch appointee, which for property rights pretty usually fell within the court's realm. As a result of all this, confusion continued in spite of the best efforts of the Utah Territorial Legislature, or the LDS Church for that matter. And church continued to administer and decree water rights. A classic example is the waters of the Spanish Fork River, which were decreed by a church high council in 1879 and continue to be governed that way or distributed that way for the large part. There were subsequent decrees, but the church high council has pretty much said this company gets this much, this company gets this much, this company gets much, and that's still how it goes today. So it's interesting. The church influence on early days of Utah territory and the state had a lasting impact on how water rights have evolved to this day. So we get into the statehood. In 1896, Utah becomes a state. There was a lot of controversy. People were really worried that the state, with its new designation, was going to come in and say, all right, we're the owners of all the water. No one has a water right. So they were going to confiscate everyone's water rights. And there was a little bit of a movement afoot to do just that. So there's a big argument, and they finally said, fine, we are just not going to even touch water at all. All we're going to do is write one provision in the Utah's Constitution under Article 17 that says, all existing rights to the use of any of the waters in the state for any useful or beneficial purpose are hereby recognized and confirmed. So that means if you had been using water and you could continue to do so, you had a right or a pre-statutory right to do so. We call these things, sometimes they're called grandfathered. The parlance that we use in the Division of Water Rights, you'll probably hear is diligence claim, okay? That's a term for rights that existed prior to Utah water law coming into effect. And then you'll hear that over and over. 1897, the Office of the State Engineer, what we now know as the Division of Water Rights, was created, but they didn't really have anything to do with water rights. They were mostly just mapping stuff. You still had to appropriate a water right by going and staking your claim and then go file the claim at the post office or the county recorder, again, which was largely ignored. In 1902, the United States Reclamation Service was created, and its mission was to reclaim the arid West. And they did that by building gigantic reservoirs all over the western United States. But one of their caveats, before they'd come into a state and do that, they would tell the state, hey, we're not going to build any projects in your state or your territory until you come up with some type of comprehensive water law. Because we want to know that if we're going to build this reservoir, we want to know that we're going to have water to be able to fill it. But if we don't know who already has existing rights, we just don't have enough surety to be able to fund this project. And so as a result of that, it's no coincidence that in 1903, the Utah State Legislature developed its first comprehensive water law, which called for appropriating surface rights, meaning now you could go and you could appropriate water rights, but you'd also record the existing rights and the adjudicating of those rights. But that was pretty much just left to the court, which is kind of a strange thing for the court to do, because if you're a judge in a courtroom, you're not actively seeking out how to figure out how water rights. You wait for cases to come to you, and then you solve them, right? Looking at the facts and the issues in the law. So you pretty much wait for issues to come to you. You don't go out looking and mapping and trying to find these water rights. So it really was a flawed system to determine all these existing grandfathered or diligence or pre-statutory rights. And plus the legislature failed to provide the adequate funding, so it pretty much fell flat on its face. In 1919, the state legislature finally figured out what to do. They adopted a system that had been in use in Oregon. The system involved the state engineer going out and doing kind of an assessment of all the water rights and then filing a proposed determination, which is kind of his official recommendation to the court. And then the court just rules on that, right? The state engineer starts the civil suit, includes all parties, issues his report to the court, and then the court waits for people to come in and oppose that, and then he has something that he can rule, right? And so that's largely the mechanism we use today, and I'm going to go into a lot more detail about what that looks like in this day and age. So you see that date in 1903, that was for surface water only. So that means that if you wanted to divert water out of Mill Creek or Jordan River, after 1903, you had to go and you had to appropriate it through the state engineer's office, or you had to get a permit. That's kind of the easy word for it, right? Well, up until 1935, you didn't have to do anything to drill a well. They finally came to the conclusion that, hey, surface water and groundwater is so interconnected, you can't just let one go freely and require appropriation on the other. You've got to bring it under the system of appropriation as well. So prior to 1935, you didn't need a water right to divert from a well. After 1935, you needed to appropriate through the state engineer's office. So when we talk about pre-statutory rights or pre-statutory claims, for surface waters, we're talking about water that was being used prior to 1903. For wells and underground water, we're talking about water that was used prior to 1935. And that's pretty important because in the Salt Lake Valley, there were a lot of wells drilled prior to 1935. In some of these communities, that was the only way to get domestic water to their houses until Salt Lake City or some other public water supplier built the infrastructure to reach those houses. So there may be, and we've had plenty of them, and maybe they're in your backyard, people who have wells that were once connected to their house, or maybe they still are connected to their house, providing that domestic source of water. And so this is an opportunity for them to bring that claim forward and get it on their records. Otherwise, there's some pretty severe consequences if you fail to do that, and I'll talk a little bit about that. So prior to the enactment of that comprehensive water law in 1903 and then again in 1935, water fell into a combination of 5 different categories. You had those rights that were decreed by the ecclesiastical leaders, the Spanish Fork River High Council decision being a prime example. Claims that were filed for record at the county, they were pretty much just, that could have been through the selectman or the person themselves, the claimant themselves. You had rights that were decreed by a court. Again, this usually only happened when people got irritated with each other and they took each other to the court, and the court would settle the issue between those parties. But they didn't settle the issue between those parties and everyone else. And so those decrees were limited in respect to the number of parties and how comprehensive they were. You had water rights that were pretty much just based on exchange contracts or contracts between a municipality or water user. You have a lot of those in the Salt Lake Valley, where the Salt Lake City, to provide domestic water to their growing population, agreed to give certain irrigation companies water from the Jordan River, a more secure source, right? Because Jordan River is always flowing out of the Utah Lake, in exchange for the clean water coming out of Little Cottonwood Creek or Big Cottonwood Creek or Parley's Creek, because that was easier to purify, treat. It was also higher up in the system, so they could store it and serve it to Salt Lake City. So there are, 50 some odd exchange agreements that I know of where Salt Lake's gone in and done this amongst different entities. And then it doesn't have to be between public water suppliers or municipalities. It could be between individuals as well. And then you had those claims that never manifested themselves on any record. These are those old grandfathered rights, the surface rights prior to 1903, the groundwater rights prior to 1935, where they had no reason to come forward to file a claim because they were using the water, didn't really have any issues. Maybe everyone was leaving alone, so they never filed a claim. Well, as a result of this, there's a number of issues. First, there was no public record. There certainly wasn't a consolidated public record. You couldn't go to one place and look for all the water rights on a certain creek or a certain part of the state. Because of that, over-appropriation was pretty rampant. You have many cases where more water was appropriated out of stream than actually flowed in that stream. And because it was over-appropriated and the rights weren't defined, there was a lot of controversy that had to be settled through ecclesiastical or court channels. In his biennial report, the state engineer at the time made the following observation. Now, keep in mind, this is 1901 and 1902, so this is prior to the first water law in 1903. He said, "The definition of existing rights appears to be of first importance. This is not only so, those are the rights that had already been being used. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record." So the idea was, hey, we are going to go and find all these old rights first, bring them onto the record, then we'll start appropriating new water rights. Sounded great in theory, but the problem is finding all these old rights was a huge task. People grew impatient and they decided, tell you what, we're just going to do these two things at the same time. We're going to appropriate new water rights and find these existing water rights as we go along. So, and that leads us today. What is a general stream adjudication or a water rights adjudication? We just call it an adjudication around here. Well, as the name implies, it's an action in state district court. For this particular case or this subdivision, it's the Third Judicial Court. There at the Matheson Courthouse, Judge Scott is the presiding officer. It binds water users and the state engineer. So unlike other decrees, which only had limited number of parties, maybe one or two, this binds everyone in the drainage. Everyone is a party to this proceeding. That's the title of code that it's governed by. And the first general stream adjudications took place in the 20s. Again, you remember in 1919, the state legislature finally got around to figuring out how to make the court system work. And so they started initiating adjudications in different drainages. Up here in the Weaver River drainage, you can see it was started in 1919. The Virgin River, 1923. And then they came back in 1980 and decided to do it again at the request of the water users. Sevier River, 1920. And then a lot of these you'll see have 1950s dates, and there's a reason for that I'll get into later. The general adjudication that we're talking about tonight, of which the Dimple Dell is simply a small bite in it, a small subdivision of it, is this big purple blob right here, the Utah Lake Jordan River General Adjudication. So it stretches all the way up into the northern reaches of Salt Lake County, down here, up into Heber, in Spanish Fork, and down here, what's this down here? Goshen, right? So it's the entire drainage that we're talking about, trying to get this is the civil case that we're involved in, of which the Dimple Dell Subdivision is just one bite of that. So why do we conduct the general adjudications? I kind of hinted at it before. We want to bring all the claims onto the permanent record. That includes the diligence claims, or the surface water rights that were happening before 1903, as well as the underground water claims. And those are the water, the wells, and the underground water that was being used prior to 1935. We also have these things called Federal Reserve water rights. Now, it has nothing to do with the Federal Reserve that prints money. It's actually a doctrine that was developed out of Supreme Court case precedent. Back around the turn of the century, there was the Indians on the Fort Belknap Indian Reservation. They're trying to get along, trying to make a living as intended on the reservation, and they went to go appropriate some water out of the Milk River in Montana. And the state engineer in Montana said, well, I'm sorry, you're out of luck. All the settlers have appropriated all the water in this river. There's no water to appropriate for you guys. So good luck figuring that out. Obviously, they took him to court. The Supreme Court ruled that because Congress had made the reservation, in essence, carved the reservation out of the public domain and set it aside for the express purposes of supporting the tribe, that there was an implied water right that went with that reservation. So why is that important to us? Well, that's what we call the Winters Doctrine, established in 1908, that there's a federally reserved water right for these reservations. Well, it's important to Utah. Well, first we have some Native American reservations in Utah, but subsequent case law evolved that reserved federal water right into applying to other types of federal reservations, such as the Forest Service grounds, national parks, national monuments. All of these, because they have been reserved by Congress and set aside, or even by the president through executive authority, they were set aside. They have these implied water rights that go with the reservation. Now, the priority dates are equal to the date of the reservation in most cases, well, in all cases. But the problem is, no one could figure out, okay, no one could tell the federal government, all right, so you have this Federal Reserve water right, fine, we'll concede on that point. How much is that water? How much water are you reserving for that reservation? And the federal government says, I don't know, whatever we want, I guess. And so there was no way to force them to quantify that because the federal government enjoys this federal sovereign immunity. Well, in 1952, a senator from Nevada, Senator McCarran, drafted some legislation that said the federal government's going to waive its federal sovereign immunity with respect to water rights adjudications as long as they're done on a comprehensive basis. So you remember all those adjudications that got started in the 50s? That's because that's when that bill passed in 1952, and everyone thought, hey, we've got to figure out what the federal government thinks they have in water rights. And so that's the general adjudication, or water rights adjudication, is the only system I know of that the federal government waives their sovereign immunity, as well as we force them to appear in state district court. It doesn't go to a federal court. So they've got to come and provide their claims to us, and then they have to abide by the district court's ruling. Another reason we want to do this, we want to avoid people suing everyone and a multiplicity of suits. We want to bring clarity, resolve all these contentions and these controversies. So here's one that's a little bit more controversial whenever I bring it up, and I'll probably get the blood going here, and this may be where I get most of my questions, or where the questions start to manifest themselves. In the western United States, because there's not enough water for everyone who wants water, there's this concept of use it or lose it. So if you appropriate a water right and you don't use it for a period of 7 years in Utah, it goes back to the public. In essence, it's forfeited back to the public domain, meaning you lose it, okay? And you say, well, that's not fair, that's not fair. And I can understand that, and I certainly empathize with that, because it's unlike other property rights, like if you don't use your pasture for 7 years, they don't just say, oh, you lost it. Well, because water rights are a usufructuary right, there's certain provisions to help prevent monopolies, but also to help people protect the reliability of their water source. And you might say, well, how is that protecting the reliability? How is that making it any more reliable? And I would suggest, so if you think about it, if you have a senior water right and you stop using that water right for 20 years or so, well, that water is not just stopping and not going anywhere. That's going downstream, and other people have appropriated water rights and have started using that water. Maybe they've built a house, maybe they've built entire communities based on that water that you haven't used. So if one day you were to resume use instantaneously, that would certainly impact these people who have become reliant on it. So most of the Western states have this type of provision, a use it or lose it. That's just to ensure that water is being put to beneficial use, that there aren't monopolies, people aren't gathering up water rights and then hoarding them and using that as leverage to extort money or whatever from others. And so that's, in Utah, it's 7 years. And so if you haven't used your water in the last 7 years, it could be subject to forfeiture. We want to obtain final comprehensive decrees on all the water rights within the respective drainage. So at the end of this, we'll get a decree on this little bite-sized subdivision. And then once we go and get all the subdivisions done in the Utah Lake Jordan River general adjudication, we'll get one last final decree just to set things in stone. So here's the adjudication process. It's a three-phased process, I like to say. You have the first phase, which started off with the petition. The Utah Lake Jordan River actually started differently. It started through a court case that the court then said, oh, you'll have to solve this in the general adjudication. It happened in the 30s when there was a big drought. Salt Lake City sued like 2,000 people on the Jordan River because they had illegal pumps in the Jordan River. So the court said, hey, I can't settle this because it affects more than just the people of the Jordan River. We're going to turn it into a general adjudication. So step number 2 is what we published in the newspaper. Step number 3 is what you received in your mail. And step number 4 is what we're doing tonight. 5 through 9 will happen in the next little bit. So, and I'm going to get into these in a lot more detail in the next couple of slides. So I'm just going to fly through these. So in essence, the next part of the process is filing claims with the division and then publishing the list of unclaimed rights. Again, I'll talk a little bit more about that. We'll have a public meeting, a decree on that. And then we'll file our proposed determination with the court. We'll come out and we'll evaluate the claims. Our teams will meet with you, look at what you're claiming, and validate it, and then file that with the court as our recommendation, and ultimately have another public meeting, and then have a decree on the state engineer's recommendation. But let's kind of dig into what your next step's going to be. So I think Josh maybe stepped out, but I think we're sending the notice to file claims will be being sent out next week. Is it next Friday when that goes out? Yeah. The 27th. Okay. So we're going to be mailing out a notice to you that it's time to file a claim. For property owners, it will be a blank water user's claim. So you have a notice letter, and then you'll have this claim form that has places you can fill out your claim, all right? If you're a water right owner of record, meaning you're on our records, the state engineer's records is owning a water right, you'll get a claim form that's already filled out with all the information that we have on our database already, okay? We'll also publish this notice in a newspaper, and just to make sure everyone gets adequate notice. You will then have 90 days to file your water user's claim. You can file it here at the state engineer's office, or if you want to go the hard route, you can file it at the Third District Court. It's easy. If you want to come in, we'll help you fill out your water user's claim, and then we'll file it just upstairs. And no charge or anything. It's just a pretty easy thing for us to do. Or you can do it yourself, and you can mail it into us, or you can file it with the court. Again, you got to do it in 90 days. There is an opportunity, if you can't do it within that 90-day time frame, you can request a 30-day extension, but you've got to request that extension within that initial 90 days, okay? So you have to have up to 120 days. Yes, sir?
If we get a form and it's pre-filled out with our existing water rights, and we agree with it, we just basically need to sign that we agree and return it to you? Or?
Yeah, let me just repeat your questions for the benefit of the online community here. So this question is, if we're a water right owner of record and we receive a claim form with all the data already populated, all we've got to do is sign and send it back? And the answer is yes. Unless you disagree with it, you can always redline it and do whatever you want. But for the most part, simply sign it and send it back. It's pretty straightforward. But again, do it within that initial 90 days or 120 days if you get an extension. And that extension is automatically granted. You don't have to have justification or anything. You can email me, email anyone at Water Rights, or not anyone at Water Rights. email that address you saw or is in the notice. That's the best place to email it. Or we have a form online. You can fill it out and bring it in. Yes, sir?
So 90 days, if they're sent out July 27th, the 90 days would be October 27th?
So the 90 days is actually 90 days. And I'm not sure, I don't think it's probably going to be in that ballpark. Yeah. Yes, so it's the date of the mailing is the statutory. So if it goes out on the 27th, it's 90 days from that day forward. I think Josh is doing some quick look up and he'll get back to you. But yeah, it's in essence 90 days from when it's mailed. Once we receive the water user's claim, Josh's team will try to make contact. We encourage people to put their email address and their phone number so we can contact you so that you can be present when we evaluate your claim. It's really hard to get a hold of people via mail and it's kind of slow. But we've got to come out and we've got to investigate the claim you've made. So if you've claimed that you're irrigating your quarter-acre parcel with a well, we're going to come out and we're going to look for the well. We're going to look for how you're actually irrigating with that well on that parcel. Okay, we're going to validate the claim. We've obviously had people file bogus claims, and we've come out and just couldn't justify it. And so we've simply recommended that those claims be disallowed to the court. Did you find the date on that, Josh?
October 25th.
Yeah, October 25th is the last day in the 90-day period. All right. So let's talk about the list of unclaimed rights. This is for those of you not very familiar with water rights and how this works. So upstairs we have a big file room that's just filled with file jackets, and they all have water right numbers on them. And these are water rights where people have appropriated or filed a permit and received a water right. And so those are what we call water rights of record, meaning we have them on our record. A water right not of record would be one of those pre-statutory rights that there has been no claim filed on it yet, okay? So when we talk about a list of unclaimed rights, we're only talking about unclaimed rights of record. And so what happens is if we send out notice to these owners of record and they fail to file a claim, their water right that we have on our records will go in this list of unclaimed rights, okay? And we will send out notice to everyone when this list is compiled. Everyone that received the notice of the summons will receive the notice of this, and it'll tell you how to gain access to this. And it will essentially be a list of water right numbers, the person's name, and the location, the point of diversion. And then it'll be an alphabetical index as well, so if you want to look up, see if your name's in there somewhere. And so this list of unclaimed rights will get published. We'll have another public meeting. And then what the list of unclaimed rights is we're saying, hey, people have not participated who own these water rights. And that's for good reason in a lot of cases, because as you've noticed, the valley's urbanized. Old wells that were once irrigating agricultural fields or whatever have now turned into Walmart parking lots and been abandoned. And so people sometimes just, hey, these rights just go away. People don't stay up to date on them. Well, what will happen is these unclaimed rights will be ruled to be abandoned by the court. And so we send this list out hoping that people will, if their name's on it and they want to claim a right, that they'll file an objection and file their water user's claim, okay? So you'll have 90 days from when that notice is sent to file an objection with the court along with the water user's claim for that water right. Scott? Yeah, you have to file both. No, the objection, and there's actually the court, so the question was, do you file them together, and is there any format for the objection? So the court's been pretty good. They actually have a form that you can use on their website. That's on the court's website, it's not on our website. And I can certainly, if you have a question on how to get there, I'm happy to show you. But they have a little form, it's a legal filing, you have to go file it with the court clerk, and you have to file your claim at the same time with them. You also have to provide a copy of the water user's claim to the state engineer. So those are statutory provisions. That's just how that rolls, okay?
It has to be with the court.
Yeah, so the claim and the objection at the court, claim to us, or a copy of the claim to us, yeah. We'll get it either way, but the statute says you're supposed to file it with us, but the court clerk sends it to us anyway. So, I mean, we'll get it one way or another. We usually don't oppose those objections just because we want people to file their claims. Now, if there's some kind of ulterior motive where someone's just looked at the list of unclaimed rights and decided, I'm just going to file a claim on all of these and claim them for myself and then sell them off. Yeah, we'll probably oppose that and litigate that. But for the most part, if people have good reason for just failing to file a claim, we don't oppose it, and the judge simply rules that the claim is ruled timely, and then we'll evaluate it like any other claim that was filed on time. Once any objections have been resolved, the court will issue a decree on the list of unclaimed rights stating that all the rights have been abandoned. He will also, or she, excuse me, he or she, in this case it's a she, Judge Scott, will issue a decree that closes that subdivision to any more assertions of these diligence claims or these underground water claims. So that means if you have one of these old grandfathered rights, this is your time, your chance to assert it. Because after the list of unclaimed rights gets a decree, you're cut off. You can no longer assert that in the future. So that's one of the benefits of this is that, hey, people have had 100 plus years or maybe 90 years to file these things. It's time to get on with our lives, because although these don't happen very often, they're very disruptive when they do get filed, because suddenly you have a new water right with a senior priority in the distribution, and it's disruptive to all the water rights in the system. All right, let's see if I've missed anything. No, I think I got it. So let's talk about the proposed determination. So when you see the word proposed determination, just think of official recommendation to the court. So that's really what that is. It's the state engineer's recommendation to the court to how the water rights should look. So what we do is we go and we evaluate these water users' claims, and then we make a recommendation to the court as to how we see it. So in some cases, if people have filed a claim and they claim 10 acres of irrigation and so many livestock on their base right, and we come out and we evaluate and we only see 5 acres and fewer livestock, we'll make the recommendation in line with what we see on the ground. And that's the recommendation that will go to the court. So the notice provision, or the people who get notice of the proposed determination, is just a little bit different than the rest of the notices in that it will only be sent to people who have filed a claim. So if you're a property owner and you receive this notice, so again, we sent out 10,000 notices to all the property owners in this area. So if you don't file a claim, then you probably won't receive notice of this. You'll get notice of it in the newspaper, but that's about it. So the proposed determination gets published. We file it with the court. We send notice to people who have filed a claim of how to access it. And it, in essence, will lay out the facets of the individual water rights. It will talk about it will list the priority date, its point of diversion, its beneficial use, the owner of record, everything. And we'll hold another public meeting just to kind of go over it. I think last time 5 people attended that public meeting, so it's a whopping success, as you can tell. Objections to the proposed determination. Similar to the list of unclaimed rights, you have 90 days to file an objection. If you don't like what the state engineer has recommended to the court, you file that objection with the court. Again, there's a template on the court's website of how to do that, but it's pretty, if you're a pro se litigant, meaning you don't have an attorney, the court's pretty generous as long as you file it with them. And we're pretty responsive. If you file something with the court, we're going to respond to it. Now, we may disagree with your objection, or we may agree. If it's a clerical error or if it's an honest, legitimate error that we made, we may not oppose the objection. We may ask the court to make to modify the proposed determination according to your objection. However, we may oppose it and we may litigate it if we don't like it, if we think we were right in the first place. So either way, we have to resolve those objections before the court can issue a decree on the proposed determination, which is kind of the final step in this process. Once those objections are resolved, the court decrees the water rights as they stand in the proposed determination or as they have been amended through any of this objection proceeding process. And then we call it wraps. Okay, so that's kind of the adjudication process. I'm going to go over now the subdivision, some statistics. You received the map, the notice that kind of looks like that. Well, you have bigger versions of these maps. Those purple dots represent points of diversion, perhaps wells or even diversions off the streams. We have a map outside, Josh. We have a couple of maps. After this meeting, you can go and they're large-scale maps, and they'll have actual water right numbers associated with these points of diversion, so you can try to find your house and see if there's a water right of record that we have on our records here that corresponds with your property. Total number of water rights of record in this subdivision is only 101. That's not very many. Most of them are underground wells. We serve, 10,854 people with notice of this proceeding. Issues and anticipated timeline. So I talked about earlier, I touched on this concept of owner of record. So our records don't necessarily reflect the true ownership of these water rights in some instances. Water rights are assumed to convey with the property silently. So let's say if you have a well and you're irrigating your yard and then you sell your property to someone else, it's assumed that the well and the water right went with the property on which it was being used to the new owner. Say it conveys implicitly with the deed, unless it's explicitly withheld. So unless I specifically say, I am excluding any water rights, or I am excluding water right 57-1234, then it's assumed to have conveyed. However, even though the ownership of the water right has been conveyed through just operation of law, our records don't automatically get updated until the new owner of that parcel comes in and says, I am now the owner of this water right, put my name and address on your records, and they do that through a process called a report of conveyance. That's not necessary during this process, but we encourage people, if they are aware of water rights that maybe are outdated or have old ownership information, to update ownership just so that they can receive the notices associated with their water rights in the future. Or if they ever want to sell them, right? It's going to be a hard time convincing someone you own a water right unless your name is on our records upstairs. Location of no proof required. Sometimes we call these NPRs. These are water rights that were appropriated during the 40s, during the World War II conflict. There weren't a lot of engineers and surveyors around to file what's called proof to get certificates. And so what would happen is in the normal system of appropriation, you appropriate a water right, meaning you apply for a water right, then you start using it, and then you have to, some years later, you have to file proof with the state engineer that you've used it, meaning you've got to have a proof map prepared by a surveyor or an engineer, and then the state engineer issues a certificate. Well, during this time, they just said, hey, for small amounts of water, we're not going to make people go and try to find an engineer or surveyor. We just don't have enough of them around. So if you have a small amount of water, we're not going to require a proof. And that was great. The problem with it is that there was never a surveyed point of diversion by a registered surveyor or a professional engineer. And so a lot of the points that we have on our maps are based on old locations of these things that may not be accurate and that were never surveyed in. And so when you look at this map, you may notice some dots are not where they should be, or if you know where your well is, but the dot shows the well maybe in the middle of your driveway or out in the middle of the road, it's not going to register to you. It's going to be a little weird. And that's because the system, there's a couple of things that come into play, a couple different variables, but part of it is sometimes there's just no proof filed on these water rights. Other issues are that public land survey system is not too great if people don't really survey things in, and that's how the water rights are located, as well as some other ArcGIS and those types of the issues. Let's talk a little bit about the timeline. July 27th is when we're going to notice to file claims. And we kind of hit on some of these. The 90-day claim filing period begins. October 25th is when the 90-day claim filing period concludes. We'll be investigating water users' claims as they come in. January of 2018, we are hoping to publish the list of unclaimed rights. That should say 2019. January of 2019, publish the list of unclaimed rights. We'll hold another public meeting. There will be a 90-day objection period. April 2019, the 90-day objection period for the list of unclaimed rights concludes. And then around February 2020, we're going to publish a proposed determination. So we've kind of pushed a lot of these back a little bit. So you'll notice there's quite a lot of time between April 2019 and February 2020, almost a year. That's because we've decided to, as we kind of march down the valley and do these subdivisions, we're going to publish a lot of these all at once. So if there are issues associated with different creeks, different mountain streams, they can all get resolved in one fell swoop rather than doing it piecemeal down through the valley. Sir?
So between October 25th and January 2018, you're going to be evaluating all the claims, visiting the points of divergent sites, and proving up the claim. Is that correct?
Well, in truth, it could be anywhere from July 27th, if someone files a claim, through February 2020, right? We can evaluate the claims. Now we're going to try and evaluate them before July or February 2020. So really what happens is my team leaders are managing 4 different books at a time, so they're trying to get these through the process because they're going to get another book dumped on top of them in a month or 2. And so really what it's more like is probably from August when claims start to be trickling in, you know, for about a year, they'll be evaluating claims. Some claims are more challenging than others. Some are easy. Some are just a well on a property. Some are more challenging if they have to do with a surface water right or an old decree. And so some may take a little bit more time. But there's no given time period, but it's kind of bracketed between those 2 windows. Oh, sir.
If you have an aquifer under your property and your neighbor's property, can the neighbor and you share a well?
Yeah, it's a great question. So this question really boils down to, can your neighbor and you share a well, maybe have different water rights out of the same well even? The answer is yes, and it happens a lot actually. If you think about it, yeah. So and that happened on a regular basis in the Salt Lake Valley where the developer would just do a small subdivision with a couple parcels and just drill one well that would feed the different houses. So it is possible, and it's possible that we might stumble across something that is already doing that. But
We've already been told that the aquifer underneath my property is not very deep.
I mean, the aquifer is under everyone's property. It's it's the entire, you know, valley floor. Depending on what strata you go into, there's different aquifers. But I mean, so really, it's just one groundwater system. It's pretty hydrologically connected, especially in some of the shallow areas. Okay. Yeah. Yes, sir.
I'm on 2.5 acres, struggling to keep my property above ground, trying to go green, you know. Is this claim process an opportunity that I can use to try and get rights?
So his question is, you know, he's on 2.5 acres. He's trying to keep his ground from drying up, or his irrigated acreage from drying up. Is this a process then in which he could maybe, is an opportunity for him to acquire more water rights? And the answer is probably not. Well, the answer is no. Just really what this process is to identify existing rights. If you want to acquire new rights, you can certainly do so. Usually how people acquire new rights in the Salt Lake Valley is they have to purchase them from someone else and then file what's called a change application saying, I'm going to buy my neighbor's water right from him, and then I'm going to file a change application and divert that water right out of my well. So there is a way to do it, but there's no such thing as free chicken in the adjudication, right? You can't. It's not a free lunch, and so you can't just make a water right out of nothing. Any other questions? I think I'm wrapping up here pretty. This is often get this question: will I lose my water right? Those who are using their water rights in conformity with the records on division of water rights have nothing really to worry about as long as they filed their claim within the prescribed time frame, because even if you are using your water according to the records, and if you fail to file a claim, that claim will still get abandoned by the court. So participate. Those who don't have a water right, or maybe using one of these old wells that was drilled prior to 1935, file a claim and bring forth evidence or provide evidence that your house wasn't built or your house was built prior to 1935. It's usually the easiest way to demonstrate that your well was pre-statutorily being used. If you don't, then you could risk being barred from future assertions of that. And then if the water has fallen out of use, if the water rights fallen out of use for a period of 7 years or more, it could be recommended to be disallowed, or even a portion of it could be recommended to be disallowed in the proposed determination. There's our contact information. Josh is there at the bottom. He's going to be your main point of contact. I'm there at the top. I'm happy to answer any questions. Let's see if anyone emailed any questions. You betcha. See if anyone viewing online, no one's asked any questions online. So that concludes the meeting. Yes, sir.
Is it similar for water companies? Are they part of the adjudication?
They are.
They have water rights as well?
Yeah.
And then how do you validate those rights?
Yeah, so it's a great question. So he asked, is this process similar for water companies? And the second part of the question is, how do you validate those water rights? So there's two different type of water companies. We need to be clear about what we're talking about. So you have irrigation companies, and you have public water suppliers. So irrigation companies are irrigation companies. They divert waters for irrigation. It's usually a private entity, whereas public water suppliers are public entities, and they generally provide municipal or domestic water. So, and how we treat those two different type of entities is different because the legislature has passed a law that insulates public water suppliers from assertions of forfeiture, as long as it's water being held in reserve for their next 40 years. So they had a better lobby than anyone else, and they got that rule in there. So they can hold more water than they're actually using. So I'll talk about irrigation companies first, and I'll move on to the public water supplier component later. So irrigation companies would file a claim just like anyone else. Their board of directors or their president would sign the claim, or their attorney, whoever is acting as their agent, file their claim, and then we would come out and we'd map their irrigation. We'd say, if they're claiming that they provide water for 100 acres, we'd come out and say, all right, show us the 100 acres of irrigation. And we would try to map it. And irrigation companies really struggle in the Salt Lake Valley to maximize the number of acres that they have historically been decreed, just because the place is urbanized, right? There's less hay fields, there's more parking lots. And so a lot of times those irrigation companies lose a portion of their water right just because it's been abandoned, it's been forfeited. So that's how we evaluate the irrigation company side of it. Yes, sir?
You said earlier about getting an engineer or surveyor to map it. Does an irrigation company have to map their however many acres of irrigation they have?
So let me answer. So his question is, does the irrigation company have to map the number of acres they have? So we will map the irrigation. We have GIS, and that's part of our job, is to map it via GIS. Now we try to work with the irrigation company saying, show us where you're irrigating. If the irrigation company wants to go out and get a surveyor or an engineer and map it and then provide that to us, and then we'll verify it, that's fine too. But usually these irrigation companies don't like to go, yeah, it's the money, right? Yeah, I belong to an irrigation company too. I get it. Hold on, let me finish up the second half of this question. I'll get to it. But so we try to work with the irrigation companies just to tease out as much irrigation as we can find. It's to preserve us, because again, we're not in the business of forfeiting rights, and we would like to see the right preserved as much as we can. But at the end of the day, we've got to have the acreage. Well, let's talk about the public water suppliers. How do we evaluate those rights? Well, public water suppliers, if they acquired water rights prior to May 5th, 2008, those water rights are ollie oxen free. Those are golden water rights. They can't be subject to forfeiture. If they acquire rights after May 5th, 2008, they have to have an approved change application. And water rights with approved change applications are also free from assertions of forfeiture. And so public water supplier water rights are pretty easy, because we pretty much see what they have on our records and make sure that they pass the common sense test, and that's what ends up being put in the proposed determination. So that's, yes, sir.
When you have a neighborhood, like we're in the Seven Springs area, it's hilly, and there's a lot of, almost everybody has either a creek bed or something coming into their property.
Mm-hmm.
And yet, one fellow up above has a lake that's huge, and nobody else has any water left because it's stopped.
Yeah, so, well, that's a good question. So this gentleman paints a scenario where he lives in a neighborhood, and there's some creek beds running through the neighborhood, and there's one gentleman who's up high who's created a pond of some sort, and no water is coming down because he's using all this for his pond. So that pond, to create a pond, you have to have a water right. So if he doesn't have a water right, then he's doing it without legal authorization. He's illegally diverting water, okay? Now, am I gonna be the water cop? No, that's not really my lane, but the Division of Water Rights does have an enforcement officer. You could always file a complaint, and then that enforcement officer would come up and say, all right, you've got to breach your pond, or you got to do that, if he does not have a water right to do that. Does that make sense? If he has a water right, then he's got a water right. He has the right to do it. Yes?
What's the process for the public land of Dimple Dell itself's water rights?
So the public land. So our question is, what's the process for the public lands within this adjudication subdivision? And so, help me understand what you mean by public lands.
Well, Dimple Dell Park itself.
Okay, so the park is owned by the county. Okay, so the county would be responsible to participate, and they are actively participating.
Park is actually owned by Sandy City.
Okay, then it's Sandy City. Whoever owns the park would be responsible for participating. And same thing for Forest Service land. Forest Service participates.
So is Sandy City actively participating?
Yeah. You can rest assured that the municipalities up and down the valley are very aware of this process, and I've met with most of their attorneys, and so they're cognizant, and they're freaking out over it too. I'm pretty sure that they're protecting their interests, the interests of their residents. I'm pretty confident there. Yes, sir.
So is this the process? I bought a home up in the Dimple Dell area recently, and there's a diversion of my property, and I looked at your website, and I didn't see a water right on there. Is this the process I should use to have it figured out?
So his question is, he bought a parcel, there's a diversion of some sort off of a creek or something like that. He looked on our website to see if there's a water right associated with that diversion. He couldn't identify anything. He's wondering if this is the process to kind of sort that out. I would say, yeah, this is the process that can help you determine if there is a pre-statutory right. Is the only way you're going to get a water right out of that diversion is if you have evidence that it was used prior to 1903. So that's kind of that's a challenge. I'm just going to put it right there.
It's not on the website, but there's a great chance that you're not going to get it.
Right, so it's more likely that there is a well that existed with the house prior to 1935, and those are pretty easy to justify creating a new water right to satisfy that pre-statutory claim. Surface diversions, sometimes people are under the assumption that, hey, there's water here, I can just take it and do what I want with it because I live next to it. So they'll create these diversions, or they'll throw a pump in or something like that. Usually, diversions that existed prior to 1903 on these surface sources are wrapped into some type of decree. So it's not necessarily, it may be a right that's associated with some decree that we have on our record somewhere, and we just have to look at it. But it's certainly, if you feel like you're using it, you want to file a claim, my recommendation is file a claim and we'll figure it out. Sir?
You talked about irrigation companies proving that they have enough land to justify their water right. Is there some standard for feet per acre, or some kind of standard you look for? What is it, if there is?
Yeah, sure. So his question is, with respect to the irrigation companies, and really this applies to any irrigation whatsoever, is there some standard that applies for how many acre feet per acre we're looking for? There is. It's called a duty value. So the duty value for Salt Lake Valley is 5 acre feet per acre. Okay, and so if you have 1 acre of irrigation, that justifies 5 acre feet of diversion. Is how that works. All right. Usually these decrees, well, some of these old decree rights, they can take all types of shapes and forms, but the basis, limit, and measure of a water right is its beneficial use. And so when we say how much of a water right do you have, we're less concerned about how many acre feet you have. We're really talking about how many acres do you have, how many stock do you have, how many houses do you have, because that's what really determines how much water is associated with that water right. But irrigation companies are usually saying, all right, I got this many second feet for this many hours. You know, I got my turn on the ditch is 40 minutes, and I can take so many cubic feet per second. And that's just kind of the old parlance of how things evolved back in the day when this concept of acre foot wasn't really understood, and sometimes these duty values were based on how many CFS per acre, or how many acres per CFS, really. So it's just something we got to tease out, but we're really more interested in the number of acres with regard to irrigation than we are to the number of acre feet. But it'll all get fleshed out when we work with the company. Yes, ma'am.
I have a question that doesn't really relate to this particular area, but if I have a deed that says I have water rights, should I do something with that to register those water rights in our?
So her question is, she has a deed, and it talks about that they were conveyed water rights, and she's wondering, is there something I should do to follow up on that? So I will say yes, you should always follow up on that, but I will also say this, that a lot of these deeds are boilerplate, and they simply say, we convey all mineral rights, all water rights, all this, that. That, you know, it's a quitclaim deed saying they're conveying all interest they have in that. Now that interest may be 0. They may have no water rights, but they're conveying you 0 interest in water rights. So I would just work with a title professional or someone who understands water rights before you get too wrapped around the axles, because you might not have any water rights. I know most deeds that I've come across will always say, convey any and all mineral and water rights, yada, 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 associated with the property. That doesn't necessarily mean that there were water rights to be conveyed in the first place. It's just a boilerplate template that title companies use. So just be aware. But certainly if you feel like you do have water rights, I would, and then again, those are going to be evidenced by wells or ditches or head gates or springs. Okay, then I would certainly look to follow up on that.
Would I do that here?
Yeah. No, you come here first, and then we can give you better instruction. We could kind of shape what you need to do to move forward to get it figured out. Any other questions? Yes.
This is probably kind of odd, but you keep saying you're going to publish it in the newspaper. I don't know how many people could take the newspaper.
Yeah.
To look at this publishing.
Yeah.
And be in on.
So her not so much a question, but really an observation on our practices of publishing in the newspaper being a little out of date. Totally agree, but it's a statute that requires it. And generally speaking, since it's a legal proceeding, that's just the way the court has decided things, notices to be provided, is through publication in a local newspaper. But that's why we don't rely on it, right? We weren't obligated to send notices to property owners. We do it because we want to make sure people are apprised of it, fully recognizing that no one is, digesting these legal notices in the newspaper and having any understanding of what that even means. But we are required to do it just because it satisfies a statutory requirement. Any other questions? Yes, sir.
I have some water rights that were conveyed to me that were B class. I was told they weren't worth anything.
So he says, I had some water rights that were conveyed to me that were B class, and I was told they weren't worth anything. Well, worth is in the eye of the beholder, right? I guess what they're worth, I doubt they're not worth anything. Usually if you have a water right, and they might be a secondary class, or in this case B class, sometimes they call it second class, sometimes they call it secondary, they're probably worth something, meaning that you have, at some stage of some river, you get some amount of water. I would bet dollars to donuts that they're worth something to someone somewhere. So, but it's up to you as to whether you want to pursue them or not. Anything else? All right, thank you very much. Happy to stand here afterwards and help anyone out if they need some help.